As it pleases the court, my lord, I appear for the applicants in this matter together with my learned friend, Advocate Gatla.
May it please you, my lord, together with my learned friends, Advocates Wild and Van Heerden, I appear for the first and second respondents.
As it pleases the court.
As your lordship pleases, my lord, the applicant has approached this court seeking a number of wide-ranging relief. We have in our answering affidavit dedicated a section to analyze that relief, and we have also pleaded the difficulties from a legal perspective of the competence of those orders. And to the extent that it may become necessary, my lord, I'll deal with some of those. But my lord, might I just commence with the issue that we need to address, and it is that of urgency. And might I ask your lordship to have regard to the following important events. If I can just ask your lordship to turn to the answering affidavit. Commencing at paragraph 53. Oh, yes, page number, sorry, my lord, page 19. And my lord, might I just preface this by the following. Your lordship would have seen we trace the events back to 2023, and we then deal with the events in February of 2024 and the date of the 1st of March 2024. And I'm highlighting those because as we take your lordship through the chronology, your lordship will see that at every turn, the applicant does not comply with its duty to account for the entirety of the time period. And particularly, my lord, in circumstances where they seek such an invasive relief that infringes on Section 16, which is an infringement on freedom of expression. So, my lord, your lordship would have seen, perhaps, my lord, just to do justice to it, might I ask your lordship to start in paragraph 45. My lord, we set out a chronology of events, and in paragraph 46, we make the point that on the outer limit and on the applicant's best case scenario, Lord, they would have known at least on the 1st of March 2024. And that, my lord, by no means means or should be understood to mean that they had no knowledge prior. We make that case and they have not filed a reply. And your lordship would know when we get to that letter, we will deal with the fact that they knew about the work that's being commissioned. They threatened an urgent application as at that time. And your lordship will see that there is dead silence until the urgent application is launched in circumstances where there had been no undertaking at all that the work that had commenced was going to stop, and that Multichoice had not given an undertaking that it was not going to broadcast the works. And my Lord, we make the point in paragraph 47 that from the date of that letter, there is a period of 4 months, my Lord, and that's the period that I was talking about, where the applicant simply remained supine, and the answering, or at least the founding papers to which your Lordship needs to look, provide no explanation at all. Lord, in paragraph 48, your Lordship will see we reference paragraph 19 of the founding affidavit. And my Lord, it is important that your Lordship should have regard to paragraph 19. If I can just ask your Lordship to turn there. Can I just ask your Lordship to start at 02-13? Yes, of the founding affidavit. No, 18.1. Can I just ask that we start at 18.1, Lord? Is this old? Oh. Sorry, but I'm told I'm looking at the old pagination. So it's 2-6. Thanks, bro. Uh, 18.1, Lord. The sinister motives of the first and second respondent appear inter alia from the fact that they refuse or neglect to furnish a copy of the documentary to myself and the other applicants, so we can determine the full extent of the unlawful and irreparable harm which the queenship is likely to suffer if it is broadcasted, and take the necessary steps, including negotiations with myself and other applicants to prevent or limit the extent of such harm. Lord, if I can just stop there. Your Lordship saw with reference to the heads why this is legally incompetent with reference to the immediate decision. And the second relief would be incompetent in any event, which is to seek to force parties to negotiate without any ambits, no possible deadlock resolution mechanism, Lord. And this also becomes important because if the relief is entirely misconstrued, agency can never arise in any event, Lord. Even if we were in a situation where they could account for the entirety of the time period. If the relief is misguided, your Lordship would ask yourself, is there blood on the wall? Is there anything that has been pleaded in the founding papers that justify your Lordship's urgent intervention? And your Lordship would ask himself the question, assuming this relief was competent in any event, is there any reason why it cannot be obtained in due course? My Lord, put differently, substantial redress is available to the applicant, and no case has been made as to why this would not become available. And if I can just, Lord, add the last point. The claim of damages is in any event available, my Lord, assuming this was correct. We've given your Lordship the reference in the decision of Hicks versus Network Technologies, my Lord. It makes it plain. That is an adequate alternative remedy that was expressed by the AD as it then was in that decision. The applicant has not grappled with these principles at all in the founding papers, to explain why these injunctions that the applicant has to overcome have been satisfied. So, in the face of the defects which we submit are irremediable, Lord, that should be the end of the matter. But if there is any reason, my Lord, to proceed beyond that, bearing in mind that I've exceeded my 2 minutes that His Lordship had given me, Lord, the next sentence becomes important in the chronology of events that we'll touch on. The deponent says to your Lordship, nevertheless, even from the scant information available, e.g. from the advertisement of the documentary by the first respondent, before the intended broadcast of the documentary, the following detrimental misrepresentations of the Modjadji Queenship of the Balobedu Royal Nation are already apparent. Lord, this is significant because in the answering affidavit, your Lordship is told about the various steps that were taken by the first respondent to publicize the works. And Lord, this admission in the founding papers, which is dealt with in the answering papers, my Lord, where we say this admission is a clear illustration that in fact they knew even prior to the 1st of March, my Lord, because we set out when the publication started, or at least the marketing and advertising started, my Lord, and chronologically, and the different platforms are set out. And from this acknowledgement, Lord, it clearly indicates that the 1st of March is, at best, my Lord, the benevolent point at which to start. But on the undisputed facts, the clock starts ticking earlier. Then, my Lord, if I might just then return, I had indicated to your Lordship that the question of urgency is dealt with in paragraph 19 of the founding papers. Having explained to your Lordship that there is no account at all by the applicant for the time period that is comprehensively set out in the answering affidavit, Lord, the high watermark of their case is expressed as follows in paragraph 19. After learning of the intention of the first respondent to broadcast a documentary featuring the applicants succeeded to secure a consultation with counsel on 28 June 2024. My Lord, if I can just pause here. Your Lordship saw in the answering affidavit that we say there is a profound misconception on the part of the applicants, because they assume that this is a documentary, my Lord, and not, of course, dealing with the fact that it is a series, my Lord, that's premised or based on events that occurred more than 200 years ago, and it is not intended to depict any of the present scenario or any characters. Proceeding with paragraph 20. On 28 June 2024, a letter of which a copy is attached as Annexure G1 was sent to the applicants by email, and the email address is stated there, which had resulted in successful communication with the first respondent earlier in 2024. And my Lord, might I just ask your Lordship to flag that date of 2024? Because in our chronology, we deal with the interactions between the parties early in 2024. And your Lordship would see that from those, there was no request or demand for Multichoice not to proceed with the series And Lord, there was no undertaking that was given even in those interactions. So there is purely an unexplained jump, my Lord, from those earlier interactions to the demand that is then made. Lord, they proceed, my Lord, they say, in an attempt to avoid the necessity to burden this honorable court with an urgent application, this letter of demand, slightly modified, was sent to the first respondent once again later on the same date. And my Lord, if I can ask you, Lordship, to turn to the actual letter. G1. That letter dated the 1st of March by the attorney. Your Lordship would see one of the misunderstandings which is dealt with in the answering affidavit is that there is no agreement. There's no signed agreement, my Lord, concluded either in the term as alluded to here or at all. There is no financial gain, my Lord, that stands to accrue or flow. So, my Lord, that's another profound misconception, my Lord. And we've explained all of this in the answering affidavit, my Lord. It's not disputed. The case has not been replied to. And my Lord, 3.1 deals with the establishment of the Modjadji Traditional Authority. Paragraph 4, my Lord, if I can jump there. Consequent to the above, our instructions are to further advise that the purported agreement between Rhythmic World Productions and Modjadji Royal Nation is null and void, as the signatory hereof does not have the authority to act on behalf of the Balobedu Royal Council, nor was it entered into by the Council. Your Lordship would apply the consequences that flow from the fact that no such agreement exists. And paragraph 5, my Lord, importantly, we hold instructions to demand, as we hereby do, that the imminent broadcasting, my Lord, and we emphasize the word imminent. So as at 1st of March, on their own version, the broadcast was imminent of the documentary series to be stayed pending consultation with our client, failing which our instructions are to launch an urgent application to Interdict, say, wherein we shall request a cost or request for a cost order against you. So, my Lord, if one just simply has regard to the demand, your Lordship will be affair with the principle that a demand must be one that is capable of being met. And that principle is applied in different disciplines of our law. If you are going to talk about, for example, my Lord, in a different context, if you want to strike, and if a court has to determine whether the strike is lawful, one of the major indicators would be, was that strike preceded by a demand? And was the demand lawful and one that was capable of either acceptance or rejection? Allied to that, my Lord, is the principle that a no answer is an answer, as your Lordship would know. So, my Lord, from what was said to be imminent and from a demand that was not answered, my Lord, and in circumstances where no undertaking had been given that the works would stop and that the broadcast of the series, which was imminent, was not going to be proceeded with. The absence of meeting that case, even in reply, Lord, problematic as that would have been, but at least one would have thought that an attempt would be made at it, my Lord, and we could have a debate on whether this answer properly belongs in reply or it should have been in the founding affidavit. But your Lordship does not even have to grapple with that difficulty because of the absence of that explanation. My Lord, if I can just ask your Lordship to make a note. In the answering affidavit, Unless you can just bear with me. If I can ask Your Lordship to turn to page 68 of the answering affidavit. Paragraph 68. It's paragraph 68 of the founding, of the answering affidavit, my Lord.
Paragraph.
Yes, paragraph 68. This, my Lord, follows in paragraph 67, where we deal with the events leading up to the 28th of June 2024. My Lord, I'm not dealing with all of those detailed events. We've dealt with them in our heads, and they've been comprehensively set out in the answering affidavit. I'm addressing myself, my Lord, to the events after we've dealt with the 28th of June, and the deponent tells Your Lordship the following. It says, in this letter, the applicant contends that in March 2024, no release date had been announced. And my Lord, now this is the demand of the letter of the 28th of June, which is dealt with in...
So there's an annex to that.
Yes. But Your Lordship does not need to go there, because we deal with its import and the first-hand respondent's response thereto. So, my Lord, in this letter, the applicants contend that in March 2024, no release date had been announced, so they did not pursue the matter. This is an unacceptable reason to take no further steps, especially because from at least April 2024, the announcement regarding the series began to include the reference to the series coming in July. If the applicants considered the broadcast would harm their rights, and in light of the fact that no undertaking to stop production was given in response to the letter of 1 March 2024, in fact, it was clear from the numerous publications and media releases that the series was going ahead in July, it was irresponsible for the applicants to simply sit back and await further developments. And my Lord, might I just add this one point? We know that they saw the adverts. We know that, at least at best for them, when they say this imminent broadcast, they had no idea as to when it was going to be broadcast, my Lord. One thing that is palpably missing from this, if it was relevant at all, was for them to ask the question, when was it going to be broadcast, my Lord? The absence of that question, my Lord, is consistent with the answering affidavit when it sets out the different dates at which this was advertised, and the fact that the date of the broadcast was communicated, my Lord, with reference to at least as early as April 2024. And that would be consistent with knowledge of when this was going to be broadcast, my Lord, and which heightens the difficulty for the applicant not having accounted for the entirety of the time period. My Lord, just a few things to highlight before I conclude, Lord. The first is, Your Lordship saw that the answering affidavit makes plain that its engagement in the course of finding information and trying to do justice to the history of the Balobedu, Lord, with the people that it did, that are wide-ranging, it is by no means an expression of a view or an endorsement of the correctness of the underlying submissions in that dispute. You know, there is no endorsement of any sort. So, yes, ma'am. And your Lordship would see that's precisely this speculative harm, which is met, my Lord, with an answer, and it's not refuted in reply. My Lord, unless there's anything else, my Lord, if we submit, and my Lord, I'll deal with it in reply if there's anything else. On the analysis of the founding affidavit, my Lord, might I just make another point, and your Lordship will recall this point from elsewhere. If your Lordship can just go to the founding papers. I'm sorry, my Lord. Your Lordship knows the demand was made on the 28th of June. The application was issued on the 4th of July, giving us Friday and a weekend to answer. This relates to events that they knew. I've indicated to your Lordship, they've been a long time coming, since 2023. My Lord, just to remind your Lordship about this principle, I'll ask your Lordship to look at the founding affidavit. Your Lordship will see the first one, two, three, four, five. The first 5 pages are dedicated to describing the parties. Yes, and the citation. My Lord, then you have, flowing from that, 1, 2, 3, 4, 5, 6, 7, Lord. You have 7 pages in which the applicants took from the 28th of June, my Lord. And I don't need to do the maths, my Lord. Even on that basis, my Lord, assuming everything else had been answered, my Lord, and they had a case, this unreasonable truncation, my Lord, to afford yourself this much period as the applicants have to put together a 7-pager, and Lord, I'm excluding the page of the deponent. Lord, unless there's anything else that your Lordship wishes me to address, Lord, and subject to dealing with issues in reply. Lord, given the importance and the significance of the matter, your Lordship saw the resources that have been expended in terms of the research, the personnel that Mr. Ndlovu brought on board, the publicity, the contracts or agreements with the advertisers, Lord, the amount of revenue or income that stands to be lost. The first and second respondents, my Lord, having been afforded the time period that I've indicated to your Lordship, took the prudency or the prudent step, my Lord, of procuring the services of 3 counsel in order, my Lord, to do justice to the matter and to ensure that we place the court in as best a position as possible. And my Lord, we've attempted, Lord, let me not say we've done that. We've attempted through a comprehensive answering affidavit, and my Lord, your Lordship would have seen, we've also, in our heads of argument, comprehensively covered different authorities with a view to assist your Lordship. And my Lord, we submit that the employment of 3 counsel is justified. But in the alternative, my Lord, if your Lordship is not persuaded that the employment of 3 counsel is justified. Both counsel have employed the services of 2 counsel. And we would ask your Lordship to strike the matter for lack of urgency with cost, my Lord, including cost of 2 counsel. And my Lord, I think in our answering affidavit we've done it the old traditional way. I'll consult regarding the scales, my Lord. I'm not sure what is the scale C and what is the scale D. That's in there. My Lord, my leaders are saying the scale is in the heads. If I can just ask your Lordship to turn to the conclusion. In paragraph, yes, 67. It's a scale C. But my Lord, might I just to save myself the embarrassment, might I just ask your Lordship to grant costs, if your Lordship is so minded, on the scale as set out from 55 to 57 of our heads of argument.
You're not seeking a turning blind costs. Specified party discuss.
Yes, my Lord, I don't believe I can ask for more than what was set out as a case for the applicant to meet.
Was the cost price for your option at
Yes, please. As your Lordship, please. Thank you, my Lord.
We know now there's no reply.
Yes.
Your client proposed time frames.
Correct, my Lord. As it pleases the court, as long as my minute friend's overrun won't be deducted from my 2 minutes, I should be able to address the court. My Lord, as my learned friend has emphasized, that is emphasized all over the papers, also in the answering affidavit, this matter is of great cultural and constitutional importance, and also of great public importance. The first applicant is the hereditary queen of the Balobedu, who is world-renowned, and I wish to stress that it is very difficult to understand why the respondents have gone the route of a person with the name of Mpapatla, who purports to be the regent. There could never have been any doubt that the first applicant is the queen, the hereditary queen, and that any other structures presented as structures of the Modjadji queenship were bogus. Now, I wish to stress that the respondents knew exactly how sensitive this matter is. It is way beyond, as far as the applicants are concerned, it is way beyond any financial issue. For the respondents, it is a financial issue. They've made a lot of claims about great financial problems that they will incur if this matter proceeds, and that is simply a secondary issue as far as the applicants are concerned. Obviously, the respondents are financially very strong. They are the mass media. Besides the fact that they are financially very strong, they are also always, they must guard against creating unjustifiable infringements of all kinds of rights. In this case, we are dealing with constitutional rights, cultural rights of the indigenous community, the personal rights of the individual rights of the first applicant. There are a number of rights that are involved here that are of extreme importance. I just wish to point out, it is of such extreme importance and so unique, that the respondents have taken a lot of time in the affidavit to say how they were sensitive, and they wanted to be sensitive, and they wanted to be historically correct, even though it is not a documentary, as they say. We haven't seen the footage, so we cannot comment on that. But fact is that it would impact on the Modjadji dynasty, of which the first applicant is the protector and the hereditary queen. So they had to take her into account much more seriously. Instead, they went to Mpapatla, the third respondent, who significantly is not opposing this application. He purports to be the regent. If my memory serves me correctly, the document included by the respondents to point to his regency is a 2006 document, and it's common cause that the first applicant became a major on 20 January 2023. So to ignore her is a great insult, not only to her as the first applicant, but also to the Balobedu indigenous communities, which they did not consult. Instead, they opted to get into bed with Mpapatla and his alternative structures. So that is of great importance. What is also of importance is the fact that it is common cause. Well, at least it is proven on a balance of probabilities that this matter, for recognition purposes only, there's no dispute that the first applicant is the Modjadji queen, but for recognition purposes, it is on the desk of President Cyril Ramaphosa. It has been sent through to his office by Kokta. So at the very least, it would be unjust to go ahead on some basis as presented by Mpapatla, who is there with alternative structures. It's also of significance that neither President Ramaphosa nor Kokta is opposing this application. And my learned friend did not refer to the fact that Mpapatla, who was actually the pivot around which information was obtained of the Balobedu and Kilobedu, Mpapatla, they obtained his permission. I just wish to point that out to your lordship. They obtained his permission, which also emphasizes that this is not one of those cases that can be easily dealt with in a facile way, as a case where freedom of speech should not be limited. They actually obtained his permission, and I refer your lordship to Annexure MCG 16 attached to the answering affidavit. In that MCG 16, it is stated by the second respondent, from Duma, that is the second respondent, and it is stated, they spoke even to Posa. Why didn't they?
The Dr. Fonseca was involved in June, July 2023. Dr. Posa came in on the Twitter handle.
No.
And that person responsible, Dr. Kikano or something.
Yes, my lord. What I wish to read out to the court. So he assured me that there is no lawsuit that is going to come, as he is comfortable with us having been granted permission by the regent. So now it is confirmed by the second respondent that he had been granted permission by the regent. So this is an important matter, and it is submitted accordingly that even if this honourable court should for some reason, and it is in the discretion of this honourable court, not regard the matter as serious, the court is already seized with this matter, and the importance of this matter is of such a high level that this court can actually deal with the matter, even if it is not urgent. However, as far as urgency itself is concerned, my learned friend has made reference to the letter of the 1st of March. He has also clarified that in the end, to place it in perspective, at that stage, no date had been set yet for publication. Even before the 1st of March, there was definitely, and I agree with my learned friend's submissions, there was public attention to the fact that the second respondent was intending and most probably proceeded to shoot footage on this issue. So I don't. That's correct. Yeah, there are two letters attached to that. Yes, ma'am.
Paragraph 5, they say on the 1st of March,
Yes.
instructions as we hereby, imminent means
Yes, my lord.
broadcasting of the documentary series is stayed pending consultation with our client, failing to meet our instructions of the application. Now, there's no response.
Yes, my lord. But that.
That's why I asked you the parties to address all the evidence.
Yes, my lord, that is correct. But remember, at that stage, there had already been exchanges between the parties, and that was carried further in the Annexure D1 of the founding affidavit, in WhatsApp messages between Professor Modjadji and the second respondent. So there were exchanges. My lord, my submission is that the applicants cannot be faulted for attempting to keep this matter out of the courts and not to burden this court with this type of matter, whereas it was clear that there had been no proper consultation with the first applicant and the structures. There had been a consultation and even permission granted by an alternative structure, which is invalid. So at that stage, it was quite acceptable when they found out that the matter would not be, it is stated in the 28th of June letter. They found out, they realized at that stage in March that the publication was not imminent. No date had been set yet. As my learned friend admitted, only sometime in April was the date actually set for publication or broadcasting in June. So then, that is something which has to be explained by the applicants. Yes.
I don't believe nowadays for TikTok. I understand TikTok is reported video you posted on social media. In this argument, this is a whole production.
Yes, ma'am.
Numerous people involved.
Yes, ma'am.
And they're arguing that some of the local Balobedu people were involved as background actors. It's not a thing that happened this morning, published Sunday.
Yes, I can see that, my lord.
They were there in the community. These people earned money from appearing in the production here. Why not at that stage? I feel the first applicant, I think that is the signed the affidavit, okay. She was hiding there.
My lord, they travel around.
Yes,
They
but
travel.
why didn't at that stage some of the loyal people came to her and said, Your Majesty, they are busy with this thing. My aunt appears there and she's a background dancer or whatever. She said that this is the story they want to tell.
My lord, my case is not, and my argument is not, that they didn't know about the production that was going ahead, but the argument is that without involving the person and the structures that were clearly the valid structures and the hereditary. Yes, the correct person and structures were not even consulted. They actually, all through the papers, your lordship will see that they repeatedly liaised with Mpapatla, the third respondent. So that is a big problem. And the fact that they went ahead and used a lot of finances, or perhaps a lot of finances, we don't really know because we're not privy to that information, but they went ahead with a production, the cost of which we cannot determine. It is not possible to do that on the papers. They went ahead with that. They did so at their peril. In fact, when they ignored the 1st of March letter, they did so at their peril. And the fact that the applicants did not go ahead with court applications after the 1st of March is because it was actually not as imminent as they thought at that stage. What happened then is, I would like to refer your Lordship to Annexure D, D1, and more specifically, the last pages. There's a number of exchanges in 2023. That is the first portion of D1. There are a number of exchanges there. But then, at the end of this annexure, about 3 pages or 4 pages from the end, it's actually more than that. Let me just see, the last page, second last page, third last page, fourth last page, the fifth last page. There are 2 dates on that page. It is the 2nd of July 2023. After that, nothing happened. So that was the initial. Those were initial exchanges, which should also have put a stop to this matter, or at least should have caused the respondents to liaise properly with the first applicant and her structures. Then we get to the 29th of May 2024. So after that, this matter was for the first time revived on the 29th of May on 2024, which resulted in an exchange starting from that of Professor Modjadji. I'm not sure that you want to spoil your good name, and there's a whole exposition of the fact that the first applicant is the one who should have been contacted and who should have been cooperated with to make this production, and the regent and the brother, there was a court case there which also took up the time of Professor Modjadji because they wanted to challenge her. Now this means that the regent, the so-called regent, the third applicant, the third respondent, he was the regent to take care of the affairs of the first applicant while she was a minor. Now he went rogue on that. He actually turned against the first applicant, and there was a lot of problems as far as that is concerned, which is conceded in the answering affidavit. So now there's a dispute. They knew very well about the dispute. Now they are at pains to say they don't take any sides. Why don't they take any sides? Simply because they know they're wrong. The third applicant isn't even opposing. They can't even use him as a witness, and they haven't. So they are all wrong as far as that is concerned, and now they just say they don't take sides. In fact, they should have taken sides, and this is another red light that is flashing for the damage that will be done by this production that was approved and endorsed by the third applicant. Then, I just want to go ahead. That is still the 29th of May, that's the next page. Dr. Modjadji in the middle of that page says why he was occupied with a brother and the uncle. Uncle is the regent, or the former regent rather. So he could not attend to the matter fully at that stage. And then on the 30th of May, the next page, the 30th of May 2024. Now this is of prime importance. This is the reply at the top of that page. The unfortunate part, Dokotela, and that is just a Sotho term for doctor, is that you are the first person we called when we were asked to project, we asked to do the project, and you gave us the runaround. Now there's no context to that. I will, however, respond to your message in detail. Now here he says, on the 30th of May, he will respond to the message of Professor Motshekga in detail. But I'm saddened by all of this because you were our first go-to person, because of our history in the movement and because of the respect we had for you. Please allow me to get back to you in detail. Katlumpo. Now this means that on the 30th of May 2024, the applicants were awaiting a reply from the second respondent. And then even to put the matter into better perspective, Professor Motshekga answers. Now the last 3 pages contain the answer of Professor Motshekga, and I would just like to alert the court to the fact that the last 3 pages are not in the correct order. The first page is in the correct order. The last page should actually be second, and the second page should actually be last, and that places everything in proper perspective. And it once again, he says, I believe you agreed, that is at the bottom of the last page, which is actually bound in to be the second last. This is from Professor Motshekga. I believe you agreed should be reviewed without, it's not proper sentence this, but it conveys the correct meaning. I believe your agreed should be reviewed without recourse to courts of law. The Rain Queen and the Royal Council are open to discussion. So there, an invitation is once again extended for the applicants to approach the first applicant, for the respondents to approach the first applicant. They once again ignored this despite the undertaking of the second respondent. They once again ignored this invitation, and this actually ends on a note where a response and interaction is invited and expected and even undertaken by the second respondent. That never happened. Now this places the matter in a much better perspective. So then, on the 29th of June, a final attempt was made to keep this matter out of the urgent court by sending a letter to the respondents and informing them that they must come into contact and negotiate to avoid an urgent application. And it is my respectful submission that at that stage, this matter could perhaps still have been saved. One must bear in mind that the applicants have never seen the footage. In fact, the respondents go so far as to say, if the applicants want to see the footage, they must pay for it, as anybody else has to pay for it. Now, this is such an exceptional case that this is not a reasonable stance to take by the respondents. So then,
they don't say that we should usual for these kind of tender reinforcement damages.
my lord, the damages were caused by the respondents themselves.
That is what they say. I can't recall that they did fight for that.
Yeah. Now, my lord, it is a totally premature argument if it has any validity at all, because there's no indication that there are any damages. What the respondents fail to do is they fail to specify how they can actually limit their damages, if there are any damages at all. There's no valid evidence to say that they will suffer damages. It's only speculation, because they do have footage that they can put in the place of that. It can be extended for proper consultations and to see if this matter can be salvaged.
Where do I find that on the paper?
Sorry, my lord.
Where do I find that on the paper? You haven't filed the replying affidavit.
No, we didn't file a replying affidavit. That is on the papers, my
How
lord.
can you make a submission that they do have other material?
They say it in their answering affidavit. They say in this way. They say that they cannot broadcast anything of the same impact. They say that obviously they can. They concede that, but they cannot publish anything of the same impact. Now, whether that will really cause damages if they try to limit the damages, no, that is in their answering affidavit. It's very clear from their answering affidavit. And then, after the 29th, on the 29th, this letter was sent. Their reply that it was sent to a generic address. There had been a previous, the 1st of May letter was also sent there, and there was a reply that it would be distributed to the correct department. Now, it is simply not an answer to say it was sent to a generic address. Obviously, it is incumbent upon the first respondent to have a system in place where urgent matters can be dealt with urgently. In any event, what happened then is they once again ignored it. It was not the first time that they ignored the communication from the applicants. They ignored it at their peril. If there is any damage to be suffered, it is of their own creation. And that's why it is not an appropriate case where damages should be tendered at all. It cannot be tendered. It would be completely unacceptable. Then I've already dealt with the Annexure D1. I've dealt with the earlier letters. I've dealt with the letters of the 28th of June. I've dealt with, I've dealt with this issue, and then the adequate alternative remedy. My lord, this is actually disingenuous. There is no adequate alternative remedy, especially not in this case, where it goes about, where it is much more than finances are involved. But nevertheless, if my learned friend cites the Broadcasting Complaints Commission as an alternative remedy, my lord, that is, I don't know how much interaction everybody in this court has had with the Broadcasting Complaints Commission, but a year or two ago I did a case before them and I won the case, and it had absolutely no effect. It's a bulldog without any teeth, and it cannot address any wrongs. And on the papers of the respondent, the only alternative remedy, according to them, is financial damages. But this is a case of constitutional, cultural, and even religious importance as protected by the Constitution. So it is completely a different kettle of fish than the normal case where financial damages can be claimed at a later stage. My learned friend addresses the fact that we drafted only 7 pages. Bill Gates once pointed out that if you can do it in 7 pages instead of in 100 pages, you've actually done a good thing, and it will take you more time, but it will be a better product. I'm not saying that we've got the top of the range product in those 7 pages, but what I can say is that we worked very hard to put everything into 7 pages after consultation with a great number of people. And my learned friend and his huge team of advocates, they compiled a document of much greater volume. And if it should be relevant, I would simply say that the bulk of the answering affidavit, much of the material in the answering affidavit is not really necessary. And to argue for 3 advocates because such a bulky document was produced is, with great respect, not acceptable. I would not argue against two advocates, a senior and a junior, if such cost is granted. And I also ask the court to grant the costs in our case, the cost of a senior and a junior, and that the court entertains this matter in any event, as is in this discretion of the court, even if the court might not agree with us completely as far as urgency is concerned. If there's anything else, I can address that, my lord, but otherwise, this is my 2 minutes has passed now.
If I'm with you, 29th June, you realize that now, why couldn't you get your papers in
My lord,
I should treat this now as extremely urgent.
yes, my lord, everything was done that was possible from my attorney's side. I was there most of the time, and they did their best to have it in. And if they missed it, they didn't miss it by a lot, I suppose. I'm not sure. Yes, my lord. Yes, my lord, I cannot take that matter much further. What I can do, however, is that the directive by your lordship and Judge van der Schuyf was not at our disposal. We didn't know about that directive. We only saw that at the end of this weekend. And then we had to file additional documentation. I must say that we were of the opinion that the matter would not be heard today, but we were ready to argue the matter today. We thought that your lordship might stand it down until later this week, but I can only apologize for any delay, and I can assure the court that there was no intention to burden this court unnecessarily. And I can only applaud the court for having been able to read all the documents in time, as it is.
Lord, your lordship would have seen one of the offenses that our learned friend with respect commits is to offend the Swissbro principle. Your lordship will recall that the Swissbro principle prescribes an injunction that it is not open to a party to simply annex papers to its affidavit without particularizing the portions on which it relies. And that is exactly what our learned friend has done. He's asking your lordship to trawl through the annexures and to make a case for a chronology that's not made out in the founding papers, and there is no indication in the founding papers that there are those portions in the annexures on which reliance is being placed. So my lord, that's, with respect, is impermissible. The second principle, my lord, to which we wish to bring your lordship's attention, my lord, is our heads of argument. If I can ask your lordship to have regard to footnote 24. Lord, it's a quotation of paragraph 25 of MIDI television, which expresses the following principle in the following terms, Lord. The basis upon which the order was made, as appears from the passage that I referred to above, was to allow the DPP to satisfy himself that the administration of justice would not be prejudiced if the broadcast took place, and in that respect, the learned judge aired. What was before the learned judge was an application for a final interdict, albeit that the duration of the interdict was limited to the period that ETV resisted submitting to the condition, and it fell to be determined in accordance with ordinary principles. The question to be considered was whether any law obliged ETV to furnish a copy of the documentary to the DPP before it was broadcast, and not whether it was reasonable to require ETV to do so. I have already pointed out that the law prohibits ETV from broadcasting material that prejudices the administration of justice. But there is no general principle of our law, whether in common law or in a statute, or to be extracted from the Constitution, that obliges ETV to furnish its material to the DPP before it was broadcast, and at least of all, a law that prohibited it from broadcasting the material unless it could first demonstrate that the publication would not be unlawful. The law generally allows freedom to publish, and freedom is not subject to permission. In the absence of a valid law that restricts that freedom, a court is not entitled to impose a restriction on its own. It's an important principle, because our learned friend spent quite some time about this permission issue, despite the fact that the answering affidavit has explained that it plays no role whatsoever. Then, my Lord, our learned friend is riding two horses. He says, firstly, they were ignored. And when your Lordship asks the question, then he gets into those engagements with Professor Moshecha. And, my Lord, those, your Lordship would have seen, they are detailed from paragraph 50 of the answering affidavit. And in context, my Lord, the answering affidavit states, this unexplained and self-created agency is only made more egregious when one considers the interactions that the production team had with members of the community in the production of the series, including persons connected to the applicants, and the extensive marketing campaign that has led up to the launch of the series. And, my Lord, the misconception in those engagements, apart from the fact that nothing controversial came out of it. As we understand the submission, it is that some sort of consensus needed to be reached. And Lord, it again misconstrues the works. This is not a documentary. It's a series for which no permission is needed. Your Lordship knows a broadcasting house, if it were to seek to write a story about President Ramaphosa, they don't need his consent. You don't need to go to him and say, Mr. President, I want to write a story about you and I need your consent. Provided, my Lord, you don't stray beyond the boundaries of what is permissible. No, and it's not a documentary, and of which this it is not. Those principles are not implicated. But, my Lord, just one thing that I wish to bring to your Lordship's attention that I didn't touch on earlier. There's an event of the 23rd of February 2024 in paragraph 58, which I have no doubt that your Lordship saw in tracing the chronology. And that, my Lord, is contextualized by what paragraph 56 says. On 22 February 2024, the series was announced to the public along with a short teaser trailer. The press release announcing the series made it plain that the series was a prime-time drama that was inspired by the world-famous Balobedu legendary rainmaker, the first Queen Modjadji. This press release has been attached as MCG2. It was clear from this release that the production of the series was well underway. The series was a drama that was inspired by the first Queen Modjadji, who lived some 200 years ago, and the series was not meant as a documentary or a factual account of either present or historical persons or events. But, my Lord, this is then the event of 23 Feb. The press release gave rise to a spate of activity, including a post on social media on 23 February 2024 by commentator Kopulo with the handle at Phil Mpela, indicating that Multichoice had been threatened with a lawsuit over the series by a member of the Modjadji royal family. So, my lord, 23 February already, there's a threatened lawsuit, so, my lord, which precedes the 1st of March in any event. A few days later, the commentator revealed that it was Tebogo Modjadji Kekana who had suggested that the series was not authorized. And again, my lord, therein lies the misconception, and would be stopped. A copy of this post and a random extract of some of the comments thereon, as well as a subsequent clarification, is attached as MGC. So, my lord, the threatened litigation, and this is the person, as your lordship would have seen, was also supposed to attend the meeting that Dr. Matthew Potts was supposed to attend, and he didn't show up. And he's a person associated with the applicant. So the threat has been there, my lord. The dispute has crystallized from a long time ago. And it is for that reason, my lord, that I was saying, if your lordship were to ignore everything else and read the chronology benevolently, your lordship would start on the 1st of March. And no meaningful or significant answer has been provided. And, my lord, importantly, the engagements as with Professor Mochega, as set out in the answering affidavit, have not been disputed. So, my lord, unless there's anything else, my lord, those are submissions, and we would ask for an order in the terms as we've asked for in our heads of argument, the strike-off together with costs on the scale as stipulated. For the judge, my lord, might I just request to be excused for purposes of the judgment?
Yes.
Thank you. As your lordship pleases, my lord. In fact, I omitted that part. I'll hang around as your lordship pleases. No. Sorry, but I forgot. I conflated, I think, the argument, because we've argued its final relief that they are seeking. I apologize, my lord, and thanks.
Thank you. And is there any other matter on the law which can be
May I recall matter number 15? delete some of them.
Well, I amended it. Amendment number 15, Mapuku versus Minister of Justice. As amended. Thank you. The court will adjourn.